That's fine. Write in there and log it. Say, refuse to make a statement. Then make sure you contact the parents. Make sure you get a letter out. Do all that stuff within 72 hours of the due process. Get the letter out within 24. Look, I know APs are busy. Okay? I always considered APs having two jobs. I was an AP for many years. You have your day job and you have your night job. Right? Who are my APs in here? High school. Yeah, well, you know what I'm talking about, right? Short-term suspension may be imposed upon a pupil forthwith and without affording the pupil or lawful custodian a hearing. Short-term suspension is an informal hearing. You don't have to have a formal hearing. Okay? Unless you screw up and don't do those things that I just told you to do. Make sure you pull them in, let them do all the things. Should you let them call mom or dad?
Yes.
Yeah, sometime, let them call them, okay? And a lot of times, like I said, if that student refuses to do anything, is totally uncooperative, just put it in there, okay? Just to protect yourself. All right, next. We've talked about notifying the lawful custodian. Now, if it's a child that's living in, I got so much stuff here, so I'm sorry if I'm a little erratic. If the child's living in a foster home, make sure that you send it to the person who is still the guardian, and maybe an agency in Topeka. Okay? Or the child will have an appointed educational advocate, as we call them. Okay? But they don't necessarily have legal rights. They have educational rights, so make sure that you send it to the proper person is what I'm saying. Because foster parents aren't necessarily legal guardians, and foster parents usually do not have all legal rights. You know what's funny in Wichita, again in a weird way, is you get kids from Garden City, Dodge City, Topeka, Santa Fe, Atchison, whatever, and they all come to Wichita, and now we've had these children's homes, they spring up like QTs. Okay? And these kids are just dumped in there. It's almost like, fraternity houses. And it's hard for us sometimes as hearing officers and school personnel to figure out who's in charge here. So you have a poor kid come to a hearing. He might have 3 people in there. He's never even seen them. They haven't seen him. Okay? Or I get people and by the way, I'm sorry I didn't introduce Miss Lori Underwood. She's my right arm. Everything. She's just wonderful. But she knows I hate telephone conferences with these agencies. Because when I get on the phone with them, I say, how are you? And they say, oh, I'm fine. I say, why are you in Topeka and not here representing your client? I have a lot of, you do? Well, then if you have too many clients, maybe you ought to, close that up and keep them in Topeka and not send them to Wichita. So I'm not real happy with those people with that. Okay? Let's see. Any questions on any of those? That's pretty.
Class, give me an example of number 11 when you said a short-term suspension would not necessarily precede a request for an extended suspension. And I know that that's true, but I was trying to think of what the example might be when that would arise.
You mean where you give a short-term suspension, okay, in lieu of?
Yeah, where you just.
Okay, what I do, what we.
You don't have to have one before you would impose an extended suspension. So
Yeah, it need not precede a proposal to impose an extended suspension, or if no short-term suspension is imposed, the pupil shall remain in school until the decision. Okay, again, I have a special ed child. They want to bring him to a hearing, second drug offense, let's say, okay, or possibly trafficking. He hasn't really caused a whole lot of problems as far as discipline. So instead of proposing an out-of-school suspension, let's just keep him in in-school suspension all this time.
Okay.
And then we'll have the hearing. Does that make sense?
Okay, so he's in end-school suspension.
Yeah, he's not going to his regular classes, no.
Gotcha.
He's not going to his regular classes. The other way would be sometime if if we've had an incident where we can still keep the perpetrator, okay, in an educational setting, in that school, without him having a lot of contact with anybody else. Great question. Okay, next please. Written notice of any proposed suspend for an extended term to expel, and the charges upon which the same is based shall be given to the pupil and to the lawful custodian. That's logical. Once you've gone past the short-term suspension, you've decided to go ahead and go for a hearing. Don't call it an expulsion hearing. Don't call it an extended. Just call it a hearing. No decision has been made. It's just a hearing. It's called an informal hearing, okay? And by definition of the courts, okay? This is not, usually what I usually just tell people is just say it is a hearing, okay? For the student and for the school. All right, so you have to let them know the time and place and all that. The failure of the pupil and the pupil's lawful custodians to attend the hearing will result in a waiver of opportunity to appeal. I have many hearings where all of a sudden they don't show up, they being the parents or the child. We have the hearing, I give them 15 minutes, then we have the hearing. It's no longer a hearing now, it becomes what is called legally a case review. So the AP and I sit down, just like we would at a hearing without the child. It's much faster, obviously, and whatever decision I make, they cannot appeal it to the board. Because they waived their right to do that by not showing up. Sometimes, are there extenuating circumstances here where something happened and they weren't? Yes, okay? But, you know, we also have a lot where they make up stuff. And I just say no. I'm sorry. All right, the hearing shall be held whenever possible within 5 school days. That's, again, that's us. Okay? But I would highly recommend that you do it that way. After the date of the notice, it shall never be later than 10 days, and that's the statute, 10 calendar days. And I've been trying to get that changed to 10 school days because of vacations we sometimes have, you know, because we run into that. That's a whole unique problem that exists at times. Obviously, a copy of the board policy, suspension, expulsion, and all that, and all the stuff that goes with it in the letter. When you send the letter out, even though it says registered letter, send it out priority mail. It's a pretty envelope, you know, it's got an eagle on it, red, white, blue, and the whole 9 yards. They stick it in the mailbox, that's the coolest part about it, and then you can track it on the computer. Okay? So when the parent says, I didn't get it, oh really? Well, it was put in your mailbox at 10:31, quote unquote, a.m. on the 5th of April. And they look at you sometimes like, wow, how'd they do that? If you send it with the green slip, you know, none of you in here, okay, are ignorant. When you get something registered mail, it's usually bad. And if you have to go get it, and you have to sign for it, you see where I'm going with this? Well, they never gave me that notice. I never got that. No, we don't go there, so we do it all priority mail now. It's cheaper too. Plus, you call Ms. Underwood on a nice day, when she's not totally busy like today for a change, she'll even show you how to get onto that stuff with the postal system right off the computer. Pretty cool, pretty slick. Notification of an extended term suspension or expulsion should meet the following criteria. The letter to the pupil is mailed to the address, blah, blah, blah. Copy obviously is sent to us. They usually, in USD 259, they have to, if it's elementary, they have to send it to the assistant superintendent of elementary, assistant superintendent of secondary, okay? So everybody kind of knows what's going on. The written notice must also include the list of witnesses. This is a biggie. It's a biggie, okay? If there are no witnesses, don't put any witnesses down. But if there are witnesses, you have to listen. So, if it's a child under 18 again, you have to have had permission, then you have to list that name. Okay? A lot of schools get upset because an attorney will call them before they call me, because obviously they don't know me, but they know the school because they saw the name of the school, and they'll say, we want such and such and such and such and such and such, you know, and they panic. The attorney is allowed to have all the materials that I'm going to have at the hearing. and he or she is allowed to see, obviously, the witnesses and all that. And the reason they want that is so they can talk to the witness ahead of time. So they get an idea, okay, as to credibility, you know, whatever else, other information they have. So sometimes my office even has to go through a subpoena process where parents subpoena witnesses to come to the hearing.
You have subpoena power, what if they don't show?
I have the power to subpoena through a judge. In other words, my attorney, our attorney in USD 259, Tom Powell, gets the paperwork, I sign it, we send it to a judge, and then they distribute it.
Then you get it all the time?
You mean, do people follow
What
the
if the judge says, the judges sign whatever?
judge will sign it?
They're not held to.
And we're not gonna, I'm not coming after them legally if they don't show up.
So
Because
it's
my parents are gonna say, there's no way my son's gonna come to this. You know, especially if it's a gang situation. I'm not gonna have a bunch of witnesses there, okay, if it's a gangbanger who's gonna possibly, you know, retaliate. So I just tell them, I say, I'm gonna use the hearing office power, okay? No. All right, next one. Applies only to disabled, education does not apply to gifted. Okay, gifted are treated regular ed. Even though they have special ed, IEPs and all that, they are a regular ed student. You can treat them just like a regular kid. So, all right, obviously, here's where it gets a little sticky again. And I know some of you are very knowledgeable about special ed more than I probably. If you have a special ed child that you're bringing to a hearing, okay, and you did the MDR, and now you decided to bring him to a hearing, you've suspended him or her for 5 days, what we try to do is we try to get the kid there even faster, so we don't burn time. Okay, so Ms. Underwood will often try to get, maybe if they've done the MDR, if the parent is willing to give up, okay, the rights, basically, then we try to bring him there in 3 days. And then I try to quickly make a decision, get that letter out so we can get him back in school somewhere, okay? Or that school will retain them during that time in an in-school suspension area. Remember, 504 now, we have to do that also for an accommodation. We also have to do an MDR for a 504 student. You have to do 2 things in that 504 student. You have to have it within the MDR. You have to look at the accommodation plan. You have to have a re-eval. It's not as extensive as a re-eval as what we know in IEPs, okay, in IDEA, special ed. But you do have to do that.
What do you do when you put the special ed, you want to not burn the days, you put them in special ed, but they won't stay there?
Then that's almost, I'll tell you, that's where I have an argument often with parents. I tell them, this is what we're offering. If you choose, okay, not to quote unquote be in there, or your son does not choose, we're going to not deal, okay, and consider that a suspension.
It's not a suspension?
No, I call it truancy. Some of them refuse to go.
But, okay,
Now, if we send them out, it's a suspension.
if you don't send them out, they just wander around. They're at school, but they won't stay there, and they're wandering around being a disruption and everything else. Then,
Well,
how do you-
I don't know, we don't let them wander around. We'll eventually put them somewhere.
you can't touch them.
I bring the police officers in, they will handle it. Or we have security, we'll handle it.
And so security don't play by the
We're
same
not,
rules.
we're not gonna have a bunch of kids roaming the halls.
I get it, but
And I can't imagine, I mean, that doesn't happen here, doesn't it? I mean, do they roam around?
no, but one of the biggest questions is when you assign them in-school suspension, but they refuse to stay or cooperate. And that is it, that is a real issue.
Okay, then, then you have obviously the option of then using an out-of-school suspension.
Right, but they're close to 10.
Okay, get the parent up there, explain to them, okay, that maybe this, we'll give you homework assignments and stuff like that. That's where, again, that creativity.
Okay, if that counts, then we're all good.
You didn't hear it from me, you know what I'm saying. Due process, you know about that with IDEA, disabled special who receive long-term suspensions will be provided FAPE. I don't know what do you do when you have a student get out? Put a student out, what do you do with a special ed student here?
Or alternate, we have a very small alternate.
Okay, so you do have for the FAPE.
Yeah.
Okay, remember, I can extend, suspend, if you will, and expel a special ed student, but I must provide him or her FAPE, which I just got to tell you earlier in the 4 core classes. Okay, that recommendation has to then come from the child study team, what they determine to be FAPE. On a 504 student, I do not have to worry about, quote unquote, providing FAPE, because he or she can be suspended or expelled with no services. That's assuming that we went through the proper, right, okay, procedures to get him or her there. All right, next. Whenever a formal hearing is to be held regarding proposed extended term, the pupil shall be afforded the following procedural rights. I think most of you probably pretty well know those, don't you? He has the right to be represented by somebody. You can have family members there. Now, I limit that to a certain degree in my room because otherwise I've had hearings where they bring the minister's sister, the minister's cousin, 15 other people, and they're all, no. And what I tell them is, folks, I'm glad you're supporting this young man. The problem is you're not a witness, you're a character witness. And I'm sorry, but I don't hold a lot with character witnesses, okay? And so, therefore, I'm pretty good about it. They're usually pretty good about it. I allow parents and 2 more people. So that's 4 people plus the student into the hearing. The administration usually brings themselves, obviously the person who's going to hold the hearing, okay, or represent the administration, if you will. And then any sort of witnesses they have. And by the way, I give you this as an open invitation. If any of you want to come to a hearing in my district, okay, in Wichita, I don't know how you would feel about that, ma'am, but they are welcome. Just give me a couple of days in advance because I have to then, I have to let them know. And the other thing is it has to be confidential completely. Okay? But it may be something that might be interesting to someone, okay, if you haven't been in a hearing in a long time. All right, so anyway, those are the rights. The right of the pupil to a fair and impartial decision. This is where a lot of parents, they'll look at me and say, well, you work for the district. And I say, yes, I do. Okay, well, how can that be fair and impartial? And I say, well, you raise a valid argument here that I am a district employee, but I said I will tell you this, in the last 3 or 4 years, I've had probably 2,800, maybe 3,000 hearings, and we've only had 10 appeals. You tell me whether I'm impartial and fair. You may not like me, but evidently a lot of parents, okay, they're saying, well, at least the guy's consistent, fair, okay, impartial. Because otherwise there would be a rash of appeals. And my board right now, they love me because this year we've had, what, almost 700 hearings? Over 700 hearings, and 2 appeals. Both of which, of course, they support me. And, so keep that in mind, because sometimes, school districts, what they'll do is they'll use their attorney as the hearing officer. But he's still an employee, right, of the district. It's hard to get around that. All right, any questions here? And by the way, may they bring their own witnesses? You betcha. It's like a court, but not the formalities. Whenever a formal hearing is held regarding a proposed extended or suspended, the administrator must make principal witnesses available. Okay, we've talked about that. Whenever a hearing results in an extended suspension, the hearing officer will determine whether the pupil in question may or may not return to class pending an appeal. I usually don't allow them, okay, once the letter goes out, they see it, and if they want to appeal, they are out, regardless of whether they appeal it or not. If the Board of Education then decides, okay, yes, he's allowed to come back, then of course, you know, we reinstate him. But here's the kicker in this. If there is an appeal, you must provide them with their assignments during that entire time. Okay? And if it's a special ed child, where are we going to put them again? Back in in-school suspension. Okay? That is if they appeal. The appeal process in Wichita is 2 board members, like a brand new hearing. And I no longer serve as the hearing officer. I serve now as the agent of the board and advise my 2 board members. Okay. All right, let's see. A written notice of the results. Once I make my decision, here's what I say to the parents in the hearing. I have 3 or 4 working days to make a decision. Working days, school days in other words. Once I make the decision, I must get the letter out within 24 hours of my decision being reached. So in a nutshell, about 5 days, okay, to get the letter into the mail after the hearing. Usually we're much faster than that, okay, especially with special ed children. Again, we try to get it out as quickly as we can. Appeal, we talked about, it has to go to the clerk of the board. Now, what happens if they didn't like the decision of the Board of Education on the appeal? Then they take it to the district court. They have 30 days to do that. The money goes to this. It costs a lot of money to have a hearing at the district court level. But that's for cases that go to the Supreme Court. They start usually in a hearing. And they get appealed. They go to the district court. They go to the appeals court, all the way up to the Supreme Court. Okay, there have been some very famous educational cases. The one most of you always are familiar with, out of Iowa, the Tinker case, right? Where they wanted to wear a patch, and they wouldn't let them in T-shirts and the whole 9 yards. Now, you know, we know that they can't wear obscenities or beer or anything that's advertised, you know, that's inappropriate in school, right? That's just for the faculty. All right. Whenever hearings result, an appeal made from such a hearing must be filed with the clerk. Board members will include the clerk, times they are typically available. Usually, my clerk of the board will put out a quote-unquote email to the board members. They'll get back with us, and then we usually have the appeal meetings at noon. Okay. Hearing officer finding letter must appeal recommendation form, including the folder. Okay, that's good. Any appeal shall be heard by the board within 20 calendar days. That's something we had changed also because of vacation sometimes, you know, Christmas vacation. We weren't able in the old days to get that in because at that time it was only 10 days. So we extended that time. Board of Education shall render its decision based upon the hearing officers no later than 5 calendar days, just like I would. In other words, the board will make its decision. By the way, what they do is they go into executive session, they come out, and they never mention a student's name, but they will say a student from South High, the appeal, and this is the decision. Pursuant to the requirements as amended in 2008 legislative and all that stuff, the safety services executive, we have, in other words, if there's a gun involved, okay? There are certain things that have to be done by the superintendent. All right? Any questions over that part? No, I'm running out of time, aren't I? Special ed. There's no excuse for any of us to ever not know whether a child is in special ed or 504. That's your fault if you don't know that. If a child comes to a hearing to me and we find out he or she's special ed, that hearing's over. Okay? And they go back. Use discipline procedure sheet. For students to determine course of action, you have that sheet, right? That's my blue sheet. That, even if it's not in USD 259, gives you a good idea as to what happens under what circumstances. for disciplinary procedures for a special ed child. Keep that somewhere, keep it handy, it's very good. And I call it the biblical sheet in USD 259 when it comes to special ed students.
They've got one that looks very familiar, I don't know how that happened.
I wonder how that happened.
I don't know.
I can't either. Ours has changed a little bit, so you may want to look at it. Okay. Schedule a manifestation determination review, and that's before the hearing, not the day of the hearing, which I've had happen. We're not going to schedule it until you've had an MDR. And then, if you still are going to go on because it was not a manifestation, then we will go ahead and schedule it. Invite parents. Look, you got to invite the parents. You can't ignore them. If they're not there, it's okay, but you have to invite them. Okay? They have that right. Should parent or guardian dissent at a hearing, or excuse me, at an MDR review? Some people get all shook up over that. All it is what they're challenging are basically that the IEP is not being properly, served, right? Or, in other words, the failure of the school district to do so, or they're saying there's something wrong with it. And so they want to obviously pursue it from a quote-unquote, in this particular case, I guess we call it due process hearing. A due process hearing officer for special ed is not what I am. I'm a disciplinary hearing officer. A due process hearing officer will be sent and picked by the state if both parties agree. In other words, they give them a list. Okay, we don't want this one, this one. Okay, we can agree on this one. Hopefully it doesn't get to that level, because when it's already at that level, we're talking about $10,000 probably. The attorneys have already cashed in. Okay, that's why I keep telling you, don't screw up, okay, in special ed. It costs money immediately. Don't screw up in athletics. I've been an athletic director, I know. Okay? Don't screw up in those areas. You know, I always used to tell, when I was in AP, I used to tell my principals, okay, if you want to spend a lot of money, get involved in cheerleading, pom-pom girls, that kind of stuff, athletics, and special ed. Mess up in any of them, get an attorney, and it goes up very quickly. Any questions about that? I still have the hearings just because the parent dissented. Okay, we still have the hearing. And all of that other stuff will be decided later. All right, please. Bring students to them if not directly involved. In other words, if the quote-unquote behavior did not have a direct relationship or was a result of the exceptionality. I mean, is an ED kid going to come in and hit somebody in the head? Walk away? That's what they do. Okay? Is an ED kid going to make an MDR for smoking marijuana? It's not going to be a manifest. It's not for that. Okay? Smoking marijuana has nothing to do with being an ED kid. So, we all know that the biggest special education category is learning disability. Okay? It is so broad, it's so easy almost to get a child into that. ED is not. Okay? By the way, if you have an ED kid without a behavior plan, I'm wondering what you've been doing. Must be a totally different quote-unquote student than what I'm used to. Okay? I used to teach ED kids for a while. They're very interesting young men and women. All right. Should we discover during the hearing that the 504 plan IEP, I will recess and make sure that we did have, that we schedule the MDR ahead of time. I've